know who is funding political parties. And this is, of course, confirming a ruling by the Western Cape High Court, which found that the Promotion of Access to Information Act, PAIA, was unconstitutional because it didn't provide for the disclosure of information pertaining to the private funding that political parties receive. Lobby group My Vote Counts had argued that for citizens to make an informed vote, there is a reasonable requirement for information concerning political parties' private funding to be disclosed. The highest court in the land found that this information must be reasonably accessible to the public and free-flowing. Janine Ogle from My Vote Counts is in our Sea Point studio in Cape Town and joins us now. Good evening to you. This is, of course, a victory for you, no doubt. Why is it so significant?
Good evening, Bongani. It's incredibly significant for the South African public and for the South African electorate. What it means is that once Parliament has put in place the provisions as required by this judgment to allow for access to information about the private funding of political parties and independent candidates, the electorate will know prior to going to the elections where political parties access their funding from. This is something that we've never had in South Africa, neither before democracy or post-democracy. So in a way, it really is a huge shift to our democratic space. It's a huge shift to our political system as well.
Some political parties, specifically opposition, had said that this in fact will weaken democracy because people won't want to fund them for fear of reprisals, for example.
Yes, so actually what you are raising is what the DA argued in the Western Cape High Court last year when they opposed our application. And our response to that was that we understand that, you know, some individuals who fund political parties have the right to their privacy, but on the other hand, the South African public has the right to access this information, and that the right of the public to access this information in this regard far outweighs the rights of a few individuals to retain their privacy. But also we have to remember that South Africa has many laws that deal with several aspects of, you know, everyday life. And if people are being intimidated, if they are being threatened, we have other laws that people can use to address that. And one of the other examples, I suppose, that has been raised around what you've just mentioned is that there are some individuals or companies who want to fund opposition parties, but who also then try to procure or have business relationships with the state. And we've responded and said, well, we have procurement legislation, policies, regulations in the country. And if that is what is happening, then that must be addressed through our procurement legislative framework.
I mean, knowing who influences the process means then you know to whom parties are beholden. And I'm thinking of the words here of Mkhweng, who said private funders do not just thoughtlessly throw their resources around, they do so for a reason and quite strategically. Some of them, of course, pouring resources because the policies of a particular party or independent candidate, for that matter, not only resonate with their ideology, but they're really hoping to influence policy to advance their own interests.
Yes, so, you know, there's nothing wrong with someone wanting to fund a political party. You can do so. It's your choice to associate with that party in that manner. But when it happens in secrecy, that it then becomes a threat to our democracy. It also threatens the trust that the South African public has in our political system, and that's also dangerous to our democracy. So we are not saying that people shouldn't be supporting political parties, but that this should take place in the open, this should take place transparently, and that if there are conflicts of interest or possible influence, it's easier to see where that is happening if there's transparency around who is funding political parties. But at the moment, with all the secrecy, People then are left to make their own assumptions, and often those assumptions, because very often in the press, we're always hearing about stories where, post the fact, we find out that people have attempted to unduly influence political parties or are benefiting from decisions made when they shouldn't be. And this erodes trust in our political system. And this is why this information must be made public. And let the public know who is supporting political parties. Let civil society and the media see who is funding political parties and give them the information to do their jobs, which is to hold people accountable and to spot where the conflicts of interest are and raise those so people know where they are.
I mean, I suppose we have to ask the critical question in this regard then, where does lobbying and special interests end and something like we saw with state capture begin?
So, I mean, if lobbying, lobbying takes several forms. Even when civil society organizations advocate for a particular point, people can say that, is a form of lobbying. But if lobbying is to take place, it must take place in the open. It must take place publicly. We know, for instance, that, in other countries, lobbying is very strictly regulated. In South Africa, it's not. Occasionally, we hear stories of how very influential people, very powerful people, in some instances companies, lobby behind closed doors, and again we find out post the fact. And all of this is very dangerous. And in terms of state capture, as an organization, and I think there's probably several civil society organizations, will be following the state capture, the Commission into State Capture very closely to see what the issues are, where the gaps are in our laws, in our regulations, in our policies, that allowed for a situation where we could find ourselves with something where we colloquially called state capture, but where an environment in which it could take place, but also that it could take place to such an extent that it is as widespread as we're seeing it to be.
Well, of course, the court has thrown the ball really back to Parliament, and it's ruled that legislators have 18 months during which they must amend PAIA. So one wonders what the impact will be for 2019. Janine Ogle there from My Vote Counts, joining us from our Cape Town studios. Now, over to Francis.
Let's continue with this theme. So political parties will have to open their books. The highest court in the land basically affirming that. We're now joined by legal expert advocate Mfesane Kasiboto. Thank you for being with us, advocate. So do you agree with the judge that this is essential for democracy?
Well, there's no doubt in my mind that it is. It's been called for a number of years now for reasons that Janine has outlined. So without a doubt in my mind, it's an important and a very progressive judgment in terms of our democratic dispensation.
Is there any right to privacy that is being approached on? Because, I was thinking of a business leader, for example, a CEO, maybe wants to give funds to a political party, but suddenly people say, oh, that company supports their party. So you're in that danger of people making the leap.
Well, of course, there's an encroachment on certain privacy rights, but you will understand that the Constitution seeks to balance those rights. So no right is absolute. So to an extent that there are democratic rights and democratic implications on the rights of an individual, the Constitution now provides for, provided it's a justified limitation of those rights, then so be it. So in my mind, though there is technically speaking an encroachment on the privacy rights of these businesses you make reference to, it's certainly a justified one in this context.
So the bigger issue is that we want to see who's offering funds for possible favors.
No, absolutely.
The court says this information must be reasonably accessible. What does that mean?
Well, it could mean anything, because you'd recall that we've got separation of powers. What that basically means is the legislature must legislate, As for what the technical processes are, it's for the legislature to determine and not the Constitutional Court. And that is the balance that the Constitutional Court, in my mind, has served very well. So in principle, this is information that must be made public for purposes of democracy. But as to what the nuts and bolts and the technical processes are, that's for the legislature to legislate on.
I've heard an idea, so you put limits, say maybe 100,000 Rand, but then can't you just mix up your donations across various time frames or across people and actually donate $1 million and not be caught?
Well, again, that's for the legislature to deal with. But the focal point of the judgment today is that information must be made public. And that is what the focal point is on. As to what that means in technical rather than procedural terms, and as far as the quantums you make reference to are concerned, that's for the legislature to legislate. It's important that we understand the primary focus of the judgment was that this is information that must be made public. For reasons that Janine has made reference to, for reasons that the Constitutional Court has made reference to, it's an important judgment.
Okay, but the legislators then will have to consider that there could be ways to get around this, some say COSATU, part of the ruling alliance, so, but not a political party. So do you donate to COSATU to get to the ANC?
Well, could well be. I mean, I do not want to preempt what shenanigans these business people and people that want to contribute will get up to. That's not for me to look at. It's not for me to comment on. The principle that I'm focused on is the fact that this is information that is imperative for a constitutional democracy. It is an issue that the legislature must legislate on. As to what they do in the background is besides the point in my mind, provided the information is reasonably provided to the people that vote.
There was the political party funding bill. So we saw political parties didn't like this at all. Then they basically came together and said, yes, we accept the political party funding bill. Now we have sort of two processes. Is that a problem?
Well, if we are to go by the reasoning of the Constitutional Court by majority, which was delivered by the Chief Justice, there isn't a problem, because we're dealing here with an issue where if a high court makes a pronouncement of constitutional invalidity of legislation, the Constitutional Court must confirm it or set it aside. So that has to happen. And that's the part of the judgment, or rather that is part of the issue that the Constitutional Court had to deal with. So in my mind, there's no issue there, because it's confirmed what was pronounced in the Western Cape High Court, and it's for now the legislature to continue with the bill, which we now understand is in process or is in front of the legislature.
So the minister was complaining about things getting stalled. It's not that we need a new bill. It just has to, Parliament has to ensure that this bill conforms to what the Constitutional Court has said.
Absolutely.
Are we behind the curve here? Are we in line with the world now, or are we trailblazing in this regard?
In my mind, we're nowhere near. I've always made the argument that we perhaps also need presidential debates before elections. This is certainly an important step towards the right direction. We have to get away from a point where what suffices for political parties is just distribute T-shirts, dry rolls filled with Viennas as a campaigning tool. It has to get to a point where the electorate is informed of the nitty-gritties of what these political parties are up to. So over and above this very important and progressive judgment, we still have a long way to go, but we're certainly facing the right direction.
Do you think laws have the power to actually do that, to make the whole process more sophisticated, to maybe even bring the population along? It's
a question of political will. When I was in varsity, one of my professors and one of my lecturers, who was very progressive, made an allegation or a suggestion that the reason we haven't gotten to a point where we're sophisticated enough to understand the nitty-gritties is because the ruling government wants to keep the people ignorant. So this is certainly a step towards the right direction. But as to whether we'll get to where we need to be to inform the electorate is a question of political will. I don't see it happening under the current government, but the more Constitutional Court and High Court challenges are brought towards the electoral system, the better in my mind. All right, thank you so much for being with us. Constitutional law specialist, advocate Mfesane Kasiboto. We take a short break and we'll be back with more news.